Welcome to my series of Back to the Basics, Employment Law. I'm Patricia Gonzalez, an employment lawyer at Parliament Clause. I act for both employers and employees on a variety of employment matters. In today's video, I'd like to talk about just cause. It's sometimes referred to as summary dismissal or termination for cause or termination with cause. Now, just cause allows an employer to legally terminate an employee immediately without notice. An employer can terminate an employee for just cause when the employee's behavior or conduct has damaged the employment relationship beyond repair. In employment law, just cause is considered the death penalty because an employee who is terminated for just cause is not entitled to any notice of termination and is not eligible for employment insurance benefits, and the just cause dismissal is a red flag to new employers, which makes it harder for the employee to find work. Obviously, this leaves a terminated employee in a financially vulnerable position, and so the courts have set a very high bar for establishing just cause. The onus is on the employer to prove just cause. If the courts find that an employer has made an improper allegation of just cause, or proceeded with such an allegation after it became clear it would not succeed, the employer may expose itself to aggravated and punitive damages being awarded against it, which would be in addition to damages for wrongful dismissal. So employers have to be very careful when alleging just cause. Now, to prove just cause, employers must satisfy a two-part legal test set out by the Supreme Court of Canada. First, the employer must prove that the misconduct did in fact occur. Second, it must prove that in light of all the circumstances, the employee's conduct damaged the employment relationship beyond repair and that a lesser form of discipline would simply not do. In addition to the two-part test, the employer also has to demonstrate that the decision to dismiss the employee for cause was made in good faith and that the employee was treated in the same manner as other employees and it was treated fairly. The courts will also consider a variety of mitigating factors that may reduce an employee's guilt and decide that a lesser punishment is warranted, in which case the employer's claim for just cause would fail. These mitigating factors include provocation or mistreatment by the employer, the nature of the work environment, for example, whether it was especially stressful or difficult, a lack of intent to harm on the part of an employee, and physical or mental trauma in the employee's personal life. The courts will also consider the length of the employee's service and associated employment record, and an unblemished record of service will weigh heavily against just cause. That being said, some types of employee misconduct that are more likely to justify just cause dismissal, and in some cases even after one single incident, includes theft, fraud, sexual harassment, sexual assault, violence, as well as secretly profiting from an employer's resources and information. Courts are also more likely to view misconduct by employees in senior positions more seriously, which may tip the scale towards just cause. While just cause generally hinges on an employee's on-duty conduct, off-duty activities that significantly damage the employer's reputation or business interests may justify a just cause dismissal. Employers are also required to address employee misconduct as soon as possible after the behavior comes to light. Courts generally view significant delay or failure to address misconduct as the employer condoning the behavior. An employer cannot later dismiss an employee for misconduct it condoned, but the employee has the onus of proving that condonation. Now, just cause is a very nuanced and fact-specific area of employment law with significant consequences to both employers and employees, and so it requires assistance of an experienced employment lawyer. I urge employers that are considering a just cause dismissal to contact an experienced employment lawyer before doing so to ensure that it is an appropriate response and to conduct the dismissal in a manner that will minimize litigation or allow the decision to be upheld by the courts. To my employee audience, if you have been terminated for just cause, it's important that you reach out to an employment lawyer to review and discuss your rights. As always, please do not hesitate to reach out to me or the employment team at Parliament Clause if you need any help with an employment matter or have an employment-related question.